Hi everybody. What I want to do in this video is talk about the Supreme Court and the checks and balances that exist between the President, the Senate, and the Supreme Court, and how that nomination process plays out. If you have not heard, Antonin Scalia died roughly 10 days ago. He was 79 years old, and he was one of the court's most conservative conservatives. So here's what the court's breakdown more or less was pre-Antonin Scalia's death. Okay? You had 4 reliably conservative justices and 4 reliably liberal justices on the court. All right, you got Scalia, Thomas, Alito, and Roberts on the conservative side. You got Ginsburg, Sotomayor, Breyer, and Kagan on the liberal side. And then you got this guy, Anthony Kennedy, who is a conservative member of the court, though on a few social issues, he can surprise everybody and swing to the liberal side. For example, in the most recent gay marriage cases, it was Kennedy that wrote those majority opinions making gay marriage legal in all 50 states in the District of Columbia and the U.S. territories. So we generally, historically, have had 9 justices on the Supreme Court. There's nothing in the Constitution that says there has to be 9. It's just something that sort of evolved out of tradition. And Congress has passed a few laws defining how many justices the Supreme Court should have on it. But that doesn't mean necessarily that 8 can't exist for a little while. So here's what generally happens, traditionally happens, after the death or retirement of a Supreme Court justice. The president will make a nomination to the Supreme Court. The president will say, I would love Robert Beveridge to be the next justice of the Supreme Court. That is the president's power. Now, the president can't just, in most circumstances, throw somebody and make them a judge. There are some things called recess appointments. I'll talk about that in a moment. But the Senate has to confirm the president's appointment, confirm the president's nominee. So the president goes, all right, Senate, I got Robert Beveridge here. He is really smart. He knows things about law and American government. And I want him to be the next Supreme Court justice. Thank you, Mr. President. I am so happy to be nominated. What will happen then is I will then go before the Senate Judiciary Committee. It's the committee in the Senate that has to do with judiciary matters. So the Senate Judiciary Committee will hold a hearing, ask me lots of questions, gather background information on me, what's been my education, what's my experience, what is my sort of take on being a justice, do I have what it takes for the job, basically. From there, the Senate Judiciary Committee will, fingers crossed, vote to recommend me to be appointed by the entire Senate. At which point, my nomination goes before all 100 senators. There could be some additional hearings, some debates about that time, and then I'll get a vote. And the Senate will say the Judiciary Committee was right. to refer you positively out of committee and say that the whole Senate should vote for me because I am awesome. Or the rest of the Senate could go, the Judiciary Committee might have thought you were a good choice. However, you don't have the legal background that we are looking for in a Supreme Court justice. The second one's not very likely. I'm totally going to get appointed and confirmed. Anyway, once I get confirmed, I take my place on the bench of the Supreme Court, and I can be there until I die or I retire. In this process, we go from there's a person on the Supreme Court. That person either dies or retires. That creates an opening in the Supreme Court that then you start with the president. The president appoints somebody to fill the position. That appointment goes to the Senate. The Senate holds hearings and decides if the president made a good appointment. If the Senate votes to confirm the Supreme Court justice that the president appointed, that justice will take their seat on the bench and be a Supreme Court justice. Simple enough, maybe? The Senate could say, no, we're not going to confirm this person, at which point the president's nominee would be rejected, and the president would have to then appoint somebody else. All right? So, checks and balances. We'll get into some of the checks and balances. The government has been set up so that there are checks and balances between the three branches of government. The idea is each branch of government, the judicial branch, the executive branch, and the legislative branch, all require each other to carry out their functions in some way or another. All right? So here's where the checks and balances are with Supreme Court and justices. All right. 1, the president has a check on the judiciary because the president gets to nominate who can become a judge. Okay? The judicial branch cannot do anything independently. Nobody can just say, I'm going to become a judge. The president has to appoint you. Okay? The president also has a check on the Senate, in that the president is the only person that can appoint somebody to be a judge. The Senate cannot say, Mr. President, Mrs. President, we do not like your nominee. Robert Babbage, we do not feel is good enough to be on the Supreme Court. So instead, we're going to vote to confirm Dan Rather. The first name that came to my head. We're going to vote to confirm Dan Rather. The Senate cannot do that. The president then says, you voted to not confirm Robert Babbage? Well, I'll appoint somebody else. And the president will just keep appointing people until the Senate confirms somebody. But the Senate cannot consider anybody that the president does not nominate. Okay, so that's a check the president has on the legislative branch. Okay. Now, the legislative branch, the Senate in this case, has a check on both the president and the judicial branch. The Senate's check on the president is that the president cannot just install anybody onto the judicial branch. The Senate has to confirm the presidential appointment, right? So the president does not have absolute power to control the judicial branch. The legislative branch, the Senate is in between there, in between the executive and the judicial branch, to make sure that there is no abuse of power. The Senate also, in this case, has a check on the judicial branch and the fact that nobody can get into the federal court system without the Senate approval. The Senate will vet the people that the president appoints, and the Senate will hopefully make sure that a bad judge gets through. Now, the justice, once they're on the Supreme Court or on any of the federal courts, has a check on the legislative branch and the executive branch's power. The justice gets to interpret the laws passed by the Senate, well, by the entire Congress actually, and figure out what the meaning of those laws is, and the justices get to decide if the executive branch is faithfully executing those laws that the Congress has passed. So Congress may pass a law saying that $100 million needs to go to building schools in Pennsylvania. The executive branch would then carry out that law. The legislative branch has said, we're going to spend $100 million on schools in Pennsylvania. The executive branch, here's the money. Now go do it. The executive branch actually carries out the laws that the legislative branch passes. The executive branch gets that money and goes, schools in Pennsylvania? Psh, I'm going to go buy a golden hot tub in Las Vegas and be super corrupt. So, president takes the money, goes down to Vegas, plays the slot machines or something, and has a golden hot tub or something. The Senate or the Congress, maybe some private citizen, could sue then the president and say, Mr. President, you're not obeying the law. You should actually do what you're supposed to do with that money. The president will go, hey, they said it could be used for money for schools in Pennsylvania. I'm having a meeting down in Las Vegas about schools in Pennsylvania. That's why I'm here. I'm just interpreting this law the way I think Congress meant it to be written. And I think this is within my executive purview. It's within my decision making. This totally reasonable and likely situation will then go before a justice who will hear the president's side and whoever is suing the president, be it the Congress or some state or another citizen who's been negatively impacted by this. And the justice will then make a ruling saying that the president has either erred in interpreting what Congress meant when they passed the law, and then the justice will order the president to follow the law. The justice will say, President Obama, you interpreted the law to mean X, but it really means Y, so start doing Y. And Obama will have to go, okay, fine, and carry out the law as the judicial branch interpreted it. One other check on the judicial branch is that the judicial branch, any of the federal courts or even state courts, they cannot hear cases unless somebody brings a case before them. Okay? Let's say in my very likely and plausible and not at all ridiculous example where Obama, I guess we're not going to say president, we're just say Obama is doing this, has taken the money for Pennsylvania schools and playing slots and sitting in a golden hot tub discussing Pennsylvania schools. Okay? if nobody decides to sue the president on this, good job, Obama. I guess you got away with it or something. The Supreme Court can't sit there and go, I can totally tell right now Obama's breaking the law. Obama is not interpreting this act of Congress correctly. This is wrong. Totally. They can sit there in their chair and talk to themselves about how what Obama's doing is wrong. However, they have zero power to do anything about it unless somebody brings a case before them. Unless somebody says, this is a problem, we need to solve it. Okay, back to Antonin Scalia, now that we know how a justice is appointed and some of the checks and balances there. A note on what is happening right now with the hole left by Scalia's death on the Supreme Court. So what's happening right now is kind of remarkable and strange and mind-blowing. Like, I personally am having a really hard time coming to grips with what is going on in the Senate right now. So under the Constitution, Obama or any president is the president for the entire 4 years they're elected. And the Constitution tells them that they have to perform certain duties. The Constitution does not say you're the president until you finish 3 years of your second term, and in your lame duck final year, you don't get to do anything at all because the people should weigh in on any decision that you make. That logic would be very weird. But the Republicans have decided that, and again, I'm surprised they're actually seem to be going through with this. I thought it would just be talk and then they would not do this. But the Senate Judiciary Committee and the Republicans that run it, because they have the majority in the Senate, have decided they are not going to even hold any hearings on any nomination Obama might make to the Supreme Court. So, not even just not hold hearings, they have said they're not even going to meet with any person Obama appoints. So Obama could fill out his constitutional duty and appoint somebody to the Supreme Court, which he will do in the next couple weeks. What would then happen next is that person would meet with the members of the Senate Judiciary Committee, do some little informal agenda setting, what are we going to cover type thing, and then the Senate Judiciary Committee would set a time for the hearings to grill the nominee on whether or not they should be allowed to take their place on the Supreme Court. The Senate Judiciary Committee members and Mitch McConnell and Mike Lee and John Conyers, who were some of the people at that press conference, all said that they are not even going to do that first step of talking with a Supreme Court nominee that Obama may make. They're literally going to do nothing on this issue. Which I'm really at a loss for words about this. Bye. Yes.